Chancellor, professors, fellow students. I feel honored to have been invited to give the first Lauterbach lectures this year, and happy to meet audiences engaged in the study of law and international relations. Here at Cambridge, about 50 years ago, I entered the international law profession under the kind and learned leadership of Professor Lauterbach and Mr. Jennings, both later judges at the International Court of Justice. Professor Lauterbach was not only the very learned professor, but also a man whose thinking was permeated by humanism and a conviction that a civilized international community, like civilized national communities, must be based on law. His legal thinking has been well analyzed in the memorial lectures given by Marty Koskinen here in 2002. I was lucky to come to the stimulating Cambridge environment, and I happily acknowledge my debt to my teachers. I can still remember a fellow student saying to Professor Lauterbach before a seminar, "You know, Professor, every morning when I wake up, I tell myself how wonderful another full day of international law." I thought that struck me as laying it on a bit thick. But I do not really disagree on substance. I have found my work exciting and never been bored. It was certainly very exciting in the first month of 2003, when I was responsible for the UN inspection in Iraq, until an alliance of willing states asked us to leave, took armed action, occupied the country, and achieved the positive result of ousting the regime of Saddam Hussein. An international drama evolved, which has cost the lives or limbs of many soldiers and many more civilians, and which continues profoundly to engage the feelings around the world. The drama is mostly discussed in terms of political wisdom, or lack thereof, but it has also raised many questions of law and international organization. I shall touch on many of these, but my presentation will not contain the detailed legal analysis that Professor Lauterbach would have required as a seminar participant. As Ellie said a while ago, I'm not quite a real international lawyer any longer. But maybe a few years from now, when I'm really retired, I will try to do that. Rather today, I should try to share with you the experience and reflections of someone who is trained as an international lawyer and who has participated in part of this drama. While my introduction today will briefly touch on the enormous expansion of international law that I have witnessed during my professional life, the focus of my lectures, as President Lauterbach said, will be on three main themes: on the use of force in the international community, on international inspections in Iraq and elsewhere, and lastly on Iraq, the use of force and the reform of the UN. For a thorough legal analysis of the question of the use of force, I would refer you to Professor Thomas Frank's excellent Lauterbach memorial lectures for the year 2000. And for a close description of the Iraq inspections, I may refer you to my own book, Disarming Iraq, which appeared earlier this year. Let me start these lectures by a few comments on the expansion of the discipline of international law as I've experienced it from 1952. Even 50 years ago, the discipline was large. Professor Lauterbach belonged to the last generation of learned professors who were able to grasp the whole area and to publish treatises on it. Oftentimes, international law, Part 1 and Part 2, edited by Professor Lauterbach, became an indispensable starting point for many inquiries. His annual digest of public international law cases was an indispensable source of cases from all over the world. Sir Elin Lauterbach, my good friend ever since my Cambridge days, has continued the digest and turned it into today's indispensable international law reports. When I was studying at Cambridge, the codification and progressive development was pursued by the International Law Commission, as it is now, and Professor Lauterbach was the rapporteur for the law of treaties. There were many specific problems which were suitable for studies by research students, and at his suggestion, I examined the question whether in cases of doubt treaties were subject to ratification or entered into force by signature. I spent months in the Squire Law Library going through hundreds of volumes of treaties in the UN Treaty Series to sift out the relatively rare cases where there was no express clause about the subject. I wanted to see if the parties then relied on some residuary rule concerning the entry into force, signature or ratification. The majority of such treaties, it turned out, became binding on signature because the majority of agreements are in simplified form, relatively few are solemn. Little did I know at the time that a few years later I would head the Swedish delegation at the Vienna Conference on the Law of Treaties. Nor did I know that the conference would not opt for my preferred residuary rule. I learned the useful lesson, however, that months of scholarly legal inquiry can become obsolete by a stroke of the legislator's pen. Although international law was a big field already in the 1950s, today's students, I'm happy to see some of them here, face a vastly bigger discipline with many new branches, the result of accelerating international integration and new fields of human activities and cooperation. Before I turn to the development of rules on the use of force, let me mention some areas of international law I have visited thoroughly and seen developed. First, the law of treaties, which I mentioned. In every community, the law of contracts is fundamental. And for the international community, the law of treaties is perhaps of even greater importance, because in this community, consensual instruments fulfill so many different functions. They may be used as civil contractual arrangements, but also to codify customary international law, or to establish new codes of conduct or constitutions of organizations. The great variety in use is reflected in the many names given to these instruments, such as treaties, conventions, agreements, pacts, compacts, charters, agreed notes, protocols, etc. It was thus of no small importance to the world that the customary law of treaties was codified in a convention, perhaps we could call it the mother of all conventions. Second, the law of arms control and disarmament. In 1962, the 18 nations disarmament conference, they are much more numerous now, the ENDC, the gangs worked in Geneva to work, and I joined the Swedish delegation as legal advisor. Mrs. Myrdal was the head, and I came to work for many years on various agreements on control, on arms control and disarmament. It used to be said in Geneva that when the lawyers were asked to move up to the table, it meant either that time had come to put the commas in the right places, or that the various delegations and parties were so thoroughly disagreed that they could only communicate through lawyers. Well, most of the time lawyers were not at the table, but they were not also without some influence. And in spite of the severe differences during the Cold War, some common interests were identified and important agreements were successfully concluded. For instance, the Partial Test Ban Treaty terminated atmospheric nuclear test explosions and prevented further large-scale radioactive fallout in the atmosphere, not an unimportant matter. Third area I might mention is environmental law. I was representing the Swedish government at the first United Nations Conference on the Human Environment in 1972, and I helped to negotiate and draft large parts of what became known as the Stockholm Declaration. It was an intense and exciting affair, and policy bases were laid for vast subsequent development through declarations and conventions. The best known is perhaps the Kyoto Protocol, which seeks to reduce greenhouse gases emissions, and which after the recent Russian ratification will now enter into force. Fourth, laws of war. After the Second World War, the Geneva Convention on Prisoners of War and many other international humanitarian matters were revised and modernized. However, it was only after the Vietnam War that the initiative was taken to modernize the laws of war, which had their roots in the Hague Conventions from the turn of the 19th century. The work led to 1977 additional protocols to the Geneva Conventions and to a convention imposing restrictions on the use of particularly injurious weapons. I shall come back to some of those. Fifth, international nuclear law. During 60 years, as Sir Elliot mentioned, I was the Director General of the International Atomic Energy Agency in Vienna. and a number of conventions and standards were adopted on nuclear safety, on the management of spent fuel and waste, and on liability for nuclear damage. The last convention took about 10 years to negotiate between the states. After the Chernobyl accident in 1986, 2 new conventions were worked out and adopted by the IAEA within the record time of 3 months, dealing with information and with assistance in the cases of nuclear accidents. So when the timing is right, international lawmaking can be very fast. And when it's not right, it can take a lot of time. 6, the rules governing inspection in the nuclear field. After the discovery in 1991 that Iraq had been able to come a long way on the clandestine development of nuclear weapons, and that the IAEA safeguards inspection had been inadequate to spot the violation, the agency took the initiative to elaborate new model safeguards agreements. When accepted individually by states, these agreements will offer more effective inspection and monitoring, and I shall deal with them, this matter of inspection, in my second lecture. I now turn to the much shakier development of the rules concerning the use of armed force. My reflections, my thoughts will reflect the experience that after a long period in which the world seemed to move to increasing, if not necessarily more effective, legal restrictions on the use of armed force, we are now facing a pressure in the opposite direction. In the discussion about the war in Iraq and about actions against terrorists, rogue states, and weapons of mass destruction, we hear it said by some that no international restrictions exist, or that restrictions which do exist may have loosened almost to the point of irrelevance. In the face of this novel discussion, I should like today to examine the perspective back in time. The Secretary Kofi Annan said in the spring of 2003 that he did not find the armed action in Iraq to be in conformity with the UN Charter. Not much attention was paid by media and the public. However, when recently, in response to an explicit question, he affirmed that this meant that in his view, the action was illegal from the standpoint of the Charter, he was sharply contradicted by some media and some high government officials. Indeed, some even asserted that it was improper for him to pronounce himself on the issue. On this last point, it should be enough, I think, to note that he is not the Secretary of the United Nations, but he is the Secretary General, and he has a mandate to uphold and defend the Charter to the best of his ability and understanding. With a bit of effort, one can perhaps find something encouraging in the pronouncement of some of the critics. They lead us to conclude, at least, that some of the critics start from the recognition that the armed action can be measured against the rules of the Charter and international law. Not all the critics do that. The story comes to my mind about President Theodore Roosevelt asking the U.S. Attorney General before the U.S. action was taken in 1915 to secure the secession of Panama from Colombia, whether a legal argument could be made to justify the action. It is reported that the high legal official replied, "Why let such a beautiful operation be marred by any petty legal considerations?" It may be comforting that the story from the U.S. is from nearly 100 years ago, before the League of Nations, the Uncovered Pact, and the UN Charter. However, having observed and listened to the governments that launched the war in Iraq in 2003, I find it hard to avoid the impression that they saw the UN Charter provisions less as real guidelines to which their states were committed than as formalities to which some courtesy had to be paid for public relations reasons. I shall return later to the contents of the arguments, including the statements by the British Attorney General regarding the legality of the armed action in Iraq. At this point, let me only note that comments made in the recent U.S. presidential election campaign suggest that the U.S. administration looked with some disdain on the relevant UN Charter rules. In debate about preemptive military actions, which both candidates thought were necessary, Senator Kerry said that such action would have to stand up to what he called a global test. The responses by President Bush and others left no doubt that the administration felt that assessing preemptive armed action contemplated by the U.S. against any outside yardstick was ridiculous, as was any idea about asking the Security Council for what they termed a permission slip. If some of the scorn voiced could be read as common election rhetoric, some high officials in the administration have been explicit in expressing the legal conviction that as Commander-in-Chief, the U.S. President can ignore the Geneva Conventions. Others have been very explicit in the view that the U.S. Constitution is the only test of the legality of an action. In remarks before the Federalist Society in Washington, D.C. on the 13th of November 2003, Mr. John Bolton, who is Undersecretary of State for Arms Control and International Security in the State Department, had this to say, and I quote him: "Our actions, taken consistently with constitutional principles, require no external validation to make them legitimate. Whether it is removing a rogue Iraqi regime and replacing it, preventing weapons of mass destruction proliferation, or protecting Americans against an unaccountable court," we have the International Criminal Court in mind, "the United States will utilize its institutions of representative government, adhere to its constitutional structures, and follow its values when measuring the legitimacy of its actions. This is as it should be in the continuing international struggle to protect our national interests and preserve our liberties." And he went on to say, put succinctly, the United States will decide what is legitimate and what is not, and can do so because of its coercive power. It is a philosophy based, at least in part, on might makes right. In a speech in 2001 about the International Criminal Court, Mr. Bolton expressed his scorn for what he termed the decentralized and unaccountable way in which international law, and particularly customary international law, is made. It is one of those international law phenomena that just happens out there among academics and activists. A little further down in the paper, he explained that if treaties cannot legally bind the United States, and he holds that they cannot, it need not detain us long to dismiss the notion of customary international law that it has any binding legal effect either. The idea that the amorphous concept of what is customary international law bind the world's nations seems to assume tacitly that the global constitution contains a global supremacy clause, but this is simply an exercise of false advertising. This is the Undersecretary of State in the State Department. The exotic doctrinal attitude expressed by him is reflected in the last few years in the forms chosen for some U.S. international cooperation. Of course, no state in today's world is able to forego treaties as incident agreements as instrumenting some international relations. Nevertheless, in the security field at least, there have clearly been U.S. efforts in recent years to avoid using binding treaties and treaty-based organizations, and a preference for informal arrangements. In discussion with Russia about the mutual reductions in the number of nuclear weapons, the U.S. first urged that no formal treaty should be used. Only after Russian insistence were the commitments laid down in the regular agreement. In a full-page article in the Financial Times, Mr. Bolton further described how a robust cooperation between the U.S. and its allies, rather than reliance on what he termed cumbersome treaty-based bureaucracies, can produce real results. He extolled the various arrangements initiated by the U.S., like the Proliferation Security Initiative, the PSI, under which participating states may intercept ships if they have concluded that cargoes comprise weapons of mass destruction-related items. What Mr. Bolton appreciated particularly in this initiative, he explained, was that these were activities, not organizations. If the U.S. government were to reject customary international law, as Mr. Bolton seems to do, the attitude demonstrated in recent years in several cases to treaty-based relations would be understandable and logical. But what else but customary international law can give treaties their international binding force? If you do not believe in that customary law or binding treaties, then why conclude treaties? Now let me turn back in history. As I was thinking about these rather fundamental issues last summer, I returned to a book by my first professor of international law, Torsten Giel, who was the international law advisor of the Swedish Foreign Ministry in the 1950s, was a sharp lawyer and an excellent historian. Belonging to the positivist school, he had no inclination to explain the binding force of customary law by referring to natural law or to a theoretical will of the state. Rather, he looked back on primitive, early human societies and noted that clans and tribes upheld strict rules demanding of their members conduct which over time had been found rational and been repeated so often that there was a firm expectation that it would be respected, a sense of duty to follow it. Deviant conduct was discouraged by revenge, taken not just by individuals, but by the collectivity to which the individual belonged. Sanctions, like blood revenge, were strong and must have functioned as considerable deterrents against conduct deviating from the expected standards. Rules also developed setting standards that should be observed in the taking of revenge enterprises. The rules were not adopted by any legislature, but developed by tradition into firm custom, which at a later stage was codified. In the absence of central authorities, solutions to conflicts often comprised mediation, conciliation, and third-party determination. It was natural, my old professor Giel said, that some rules developed in the same manner in relations between tribes as they did within tribes. Conduct and solutions found rational relations between tribes were repeated to become custom, and deviations were subjected to revenge. The customs that envoys should be violable must have developed very early. The need to be able to rely on agreements must also have existed early and led to the custom demanding respect for agreements. Often the sincerity of the intentions and the sense of obligation were manifested and expressed in elaborate procedures and oaths. The rules about control of territorial waters are likely to have arisen by, on the one hand, claims and enforcement on the part of the riparians, and on the other, acceptance or acquiescence. As Professor Giel noted, the process reminds us of the well-known words of Jean-Jacques Rousseau. Le premier qui, ayant enclos un terrain, s'avisa de dire « ceci est à moi » et trouva des gens assez aveugles pour le croire, fut le vrai fondateur de la société civile. What we can thus see is that in a number of areas customary law emerges, governing some relations between societies. For instance, the sanctity of treaties, the inviolability of envoys, the jurisdiction over the territorial sea with the right of innocent passage. No central legislature acting under a national constitution was needed for the emergence of these rules. The parties themselves interpreted the rules and upheld them by reacting in various ways against deviations. Courts did not exist, but mediation, conciliation, and other third-party determination were used. It was a primitive legal order and a primitive international community. I am aware that Professor Lauterbach's father frowned somewhat at the idea of assimilating international law to a primitive order and felt that it undermined the dignity of the law. May I be forgiven that I find the thought a bit persuasive. While early customary international law, and for that matter even recent customary international law, did not prohibit governments to go to war, the demand for some justification developed early in the day in history. In a major opus by Ian Brownlee, whom I'm happy to see here, he cites St. Augustine from AD 354 before 30 as saying that just wars are usually defined as those which avenge injuries, when a nation or city against which warlike action is directed has neglected either to punish wrongs committed by its own citizens or to restore what has been unjustly taken by it. Further, that kind of war is undoubtedly just which God himself ordains. Machiavelli, from 1492 to 1550, as one might expect, was less delicate, and in Brown his son cites him as saying, that war is just which is necessary, and every sovereign entity may decide on the occasion for war. Well, the distinction between wars of necessity and wars of choice is still used. In a reply to a question, President Bush unhesitantly affirmed that the war in Iraq was a war of necessity, not one of choice. So it still with us. While sovereigns and states tended in practice to follow the maxim of Machiavelli, they also catered for the followers of St. Augustine. And Brownlee reports that in the 18th century, Frederick the Great took great pains to produce the pretext for the invasion of Silesia. And after his invasion of Saxony, he produced evidence from the Saxon state papers purporting to show that he had merely anticipated aggression. It sounds quite modern, really. Even though in the 19th century the right to go to war was seen as unrestricted, the view was stressed that war should be a means of last resort, and the Hague Conventions did much to promote and facilitate the settlement of disputes by arbitration and other peaceful means. When today we are discussing whether the presence of weapons of mass destruction in a state in violation of commitments entered into can justify armed intervention, it may be of interest to note that one Hague Convention signed on the 18th of October 1907 contained one outright but very narrow prohibition of armed action. I quote, "The contracting parties agree not to have recourse to armed force for the recovery of contract debts claimed from the government of one country by the government of another country as being due to its nationals. The undertaking is, however, not applicable when the debtor state refuses or neglects to reply to an offer of arbitration, or after accepting the offer prevents any compromise from being agreed on, or after arbitration fails to submit to the award." Reading this 100 years old convention, we realize, I think, that the global attitude to the use of armed force has changed a bit since that convention was adopted. While in those days there were no general restrictions on the resort to armed force, as there are under the UN Charter, it had evidently not been out of question for governments to send a gunboat to some poor debtor country demanding that it should pay its debts. Today we might hear a variety of justifications for the use of gunboats, but they are unlikely to be sent to defaulting countries to collect contract debts. I think such defaults are more likely to result in the dispatch of rescue boats from the World Bank or the IMF. The second half of the 19th century and the turn of the century also saw a forceful development of rules which sought to mitigate the cruelty of warfare. We can see these rules as forerunners to our present bans on the use or possession of particular weapons, notably nuclear, biological, and chemical weapons. The 19th century started from the premise that war will be fought, and sought to outlaw conduct which was cruel and not rationally needed, at the same time not rationally needed from the military point of view. The 1868 St. Petersburg Declaration, under which the parties renounced the use of particular kinds of explosive bullets, contained the famous sentences that the only legitimate object which states should endeavor to accomplish during the war is to weaken the military forces of the enemy, that for this purpose it is sufficient to disable, thus not to kill or maim, to disable the greatest possible number of men. That this object would be exceeded by the employment of arms which uselessly aggravate the sufferings of disabled men or render their death inevitable. The Fourth Hague Convention of 1907 referred to customary international law as the residual resource of rules beyond those laid down in the convention. And in Article 23, it expressly prohibited arms, projectiles, or material calculated to cause unnecessary suffering, inter alia and explicitly mentioning poison and poison weapons. The world has traveled a long distance since the beginning of the 20th century. Some of the rules and principles of the Hague Law, banning poison and particularly injurious and indiscriminate weapons, remain relevant, while others, like the ban on the dropping of projectiles from balloons, have become casualties of modern warfare. Through modern means of communication, vastly increased international trade and finance, the world was launched on a process of integration, which has accelerated throughout the 20th century, and which today has us wired together and able to talk to each other from most points of the globe to be informed instantaneously of events anywhere. And what is more disturbing, may expose any point to long-range missiles and clandestine dissemination of biological weapons. During this period of integration, inexorably forced upon the world by modern communications, more than by far-sighted action of our own, the modest first treaty restraints on the resort of the use of armed force between states have progressed, notably through the Covenant of League of Nations, the Briand-Kele Pact, and the Charter of the UN. These developments have been analyzed by many writers, Mr. Brownlee, and regarding the use of the United Nations recently by Thomas Frank. I shall neither go into the failure of the pre-World War II period to achieve disarmament, nor into the meltdown of the pre-World War II legal restraints. In my third lecture, I shall discuss the collective security concept of the UN Charter, how it was unimplementable during the Cold War, when security had to be solved through self-defense, deterrence, and alliances. Nevertheless, let me note the following about the period after the Second World War. After the development of ever greater nuclear capabilities in a few states, perhaps through luck rather than consistent skill and prudence, the world has escaped an Armageddon, and the two superpowers escaped the mutually assured destruction, the MAD, which we talked about. We have seen some major armed conflicts in Korea, Vietnam, India, Pakistan, the Middle East, including the Iran-Iraq War and the wars in Iraq in 1991 and 2003. We have seen many lesser armed conflicts and many non-international armed conflicts. However, it may be worth recalling that while it was only 20 years between the First and the Second World War, some 60 years have now passed without such major catastrophe, and it seems, I think, increasingly unlikely that there will be such major catastrophe in the future. War between any members of the expanding European Union seems today inconceivable. The Order Neisse, which during the Cold War was a line of death, is now an internal waterway in the European Union. Any armed conflict with Russia seems highly probable, at any rate for a very long time. And European states are busy transforming their territorial defense forces for future deployment in peacekeeping and peace enforcement missions. Between the great powers and blocs in today's world, there are no territorial disputes. Perhaps some reservation should be made for the Taiwan issue. Nor are there any ideological clashes or crusades today. All seem to subscribe to various shades and shapes of the market economy, to pragmatism in foreign relations, and most states profess, but do not necessarily practice, political pluralism. International observers are common in national elections today. This is something new. After the collapse of the militant communism, global détente prevails, but armed conflicts are frequent in Africa, especially within states, and tensions and risks of armed conflicts clearly exist in three regions with unsettled borders: the Middle East, the Indian and Korean peninsulas. The much talked about war of civilizations between Muslim and non-Muslim world is totally improbable armed conflict, but not improbable in the shape of increased terrorism. When as international lawyers we look at the legal norms concerning the use of force, we need to be aware that this new, in my view, hopeful reality. In many respects, our state societies are now closely interwoven and interdependent by trade, financial and economic relations. We are also forced to regulate this interdependence by rules which still are to a large degree to emerge through cumbersome methods of consensus and by joint organizations and mechanisms. With specialized agencies and other intergovernmental organizations like the WHO, FAO, WTO, IMO, UNESCO, and the IAEA, existing and responsible for various sectors, it seems to me that a kind of administrative global authorities are emerging for the handling of common problems in their specific areas. On the other hand, in some respects, the high-tech, fast-track IT international community resembles a bunch of primitive societies rather than the civilized nations to which Article 38C of the Statute of International Court refers. The slow emergence of customary law is compensated to some extent by the treaty making, which is extensive but often require consensus building. Courts or other mechanisms for third-party determination have become much more common but are not automatically available in many situations. The most important point is that although non-belligerent relations may become normal between great powers and blocks, the possession and use of arms is still not monopolized in any single authority, as it is within the modern state. In this sense, the modern world community is similar, in my mind, to the primitive community of human societies, where peace, when it prevailed, was a result of respect for customary law and deterrence of violations achieved by the decentralized possession of arms and the readiness to use them. Over time, central authorities in individual societies, mostly kings in the past, succeeded in wielding control and did establish monopolies on the control and use of arms. At the same time, they assumed the responsibility to protect the members of the society. In many cases, they came also to accept, or were forced to accept, to act under law and to be accountable. As we are to see a world authority emerge that maintains peace globally by obtaining a monopoly on the possession and use of arms, in the same manner as the central government did when nation states were formed, or not any time soon, I think. The Roman Empire, which was well administered and militarily dominant, was able to maintain order and the Pax Romana over a very large territory. Yet it was not sustainable. Even though limited to the Mediterranean European theater, it was too large a piece to control. Today, some ask the question whether the US is consciously or unconsciously striving for a Pax Americana, based not on monopoly of possession of arms, but on a total military domination in the world, and the power and readiness to decide, if need be alone, on the deployment and use of its armed forces. Some recent developments are said to point to an affirmative answer. The current US military budget is equivalent to the military budget of the rest of the world, and US military power is by far superior to the military power of any other state. There is an emphasis on counter-proliferation, confrontation, and preemption, if need be, through unilateral military action. Points, not full bases, very often and longer, are prepared in most parts of the world to receive rapidly deployable US military forces. There is a system for regional American commanders, one for Europe, two for Asia, and one for Latin America. The recent article by a former director from the U.S. National Security Council very recently had the headline, an American pro-consul for Africa. He was actually taking the view that it would be beneficial and that there would be a better prospect of keeping the peace in Africa with an American military commander there. And I'm not critical of them. I think often they had a more realistic view of the reality than politicians. The U.S. is currently seeking to take a hard line to prevent any further state from acquiring weapons of mass destruction, but is itself exploring development of new types of nuclear weapons and is preserving the freedom to test such weapons by declining to ratify the Comprehensive Test Ban Treaty. While currently deploying considerable numbers of troops abroad, the U.S. is adamantly opposed to any arrangements under which alleged crimes by such troops could be examined by any judicial body outside the U.S. system. Notably, the International Court is opposed. The reliance on international organizations for cooperation like the UN and the IEA, and on treaty alliances and other formal agreements where relations are based on legal equality, seems to be de-emphasized. Activity under U.S. leadership, not agreement between partners, appear important. The position was taken before the invasion of Iraq, and support for the action by the Security Council was welcome, but the absence of such support would only mean that the Council rendered itself irrelevant. The position cited above, that U.S. actions in the international sphere need only be measured against the requirements of the U.S. Constitution, and that accordingly standards provided by international customary law and treaties may be ignored. These are some points that are suggested point towards a view of a customary plan. While I think American action and cooperation may often be indispensable in future cases of maintenance and restoration of international peace and security, I think a customary plan is improbable. First of all, because on reflection, I think any U.S. administration, however anxious it may be to exert influence and defend United States territory, is unlikely to want to assume the role of a global sheriff. If control of Iraq today is problematic, partly because of nationalistic feelings vis-à-vis foreign occupation, maintaining order in and between all states of the world would be beyond anybody's capability. Secondly, because the economic power may be of increasing importance, and it is much more evenly spread in the world than military power. It seems much more likely, I think, that as in the European Union, which consists of states that have fought many bitter wars between each other, that long-term development will lead the world towards some federal structure. Needless to say, movement will be very slow. Even small modifications and improvements in the structure and working of the UN will be hard to attain. But despite the currently skeptical attitude to the UN taken by the US, the organization is hardly going to become irrelevant. Let me end by citing Mr. Hammarskjöld, who said that the UN was not designed to take us to heaven, but to help us avoid going to hell. Let us hope that after the Cold War, and when some time has passed after the Iraq drama, governments will use the UN and the world organizations to take some steps further away from war.
Any expression of appreciation on my part would be quite inadequate to reflect what we would feel about the lecture we have just heard and what we look forward to in the lectures tomorrow and Wednesday. I need to say no more but to thank you all for your attendance and look forward to seeing you again tomorrow. But I do want our speaker to know that I feel very deeply that he has been good enough to come here. Thank you all.